The Supreme Court just reversed a lower court's decision to throw out evidence from a police stop, but the case reveals a fundamental tension in how America's courts decide when officers can legally pull someone over. The question sounds simple. Did police have enough reason to stop a teenager driving a car at 2 a.m.? But the answer exposes a real disagreement about how judges should evaluate suspicious behavior, and whether the Supreme Court should even be involved in cases like this one. Nine Robes uses non-partisan, everyday language to focus on the facts of what the Supreme Court is saying. Here, you'll find clear, concise summaries of every Supreme Court opinion, stripped of legalese and clickbait headlines. Each post breaks down the facts, explains the court's reasoning, and highlights the crucial details that often go unnoticed. It's not just about what the court decided. It's about why those decisions matter, to give you a deeper understanding of the cases that define our nation's legal landscape. These summaries are generated by AI. Be careful and consult reputable sources when in doubt. Around 2 a.m., Officer Vanderpool responded to a radio dispatch about a suspicious vehicle. When he arrived, 2 passengers bolted from the car, leaving a door open. The driver, a teenager named R.W., started backing up without closing the door. The officer blocked the car, drew his weapon, and ordered R.W. to show his hands. Police later charged R.W. with unauthorized use of a motor vehicle and receiving stolen property. The charge was based on evidence from that stop. The core question was straightforward. Did the officer have enough legitimate reason to stop R.W. in the first place? The lower court said no. The Supreme Court said yes, and it did so without even holding a hearing. The court signaled that the answer was obvious by skipping their regular procedure of hearing oral arguments. The Supreme Court ruled that Officer Vanderpool clearly had grounds to stop R.W. Judges must look at the whole situation, not pick apart individual facts one by one. Think of it like a mosaic. A single tile might look meaningless, but tiles arranged together create a clear picture. The court found that R.W.'s companion's running away was significant. So was R.W.'s own behavior. Backing up with a door hanging open while his friends fled suggested he knew something was wrong. Together, these facts, plus the radio dispatch, gave the officer reasonable suspicion of criminal activity. That's the legal standard police need before stopping someone. Justice Jackson dissented, but not to defend R.W.'s rights directly. Instead, she questioned whether the Supreme Court should have taken the case at all. She argued the lower court had done its job correctly. It carefully examined each fact before weighing them together. That's not the same as ignoring the full picture, she wrote. Jackson also pointed out that every court, including the Supreme Court in this very opinion, decides which facts matter and which don't. The real question is whether the lower court made a clear error. She suggested it didn't. If the only correction needed was giving more weight to the companions running away, that wasn't significant enough to justify the Supreme Court stepping in without a hearing. Justice Sotomayor noted she would have declined to hear the case entirely, signaling concern about whether this was the right kind of case for the nation's highest court to decide. Police need reasonable suspicion before they can stop someone. That's a lower bar than probable cause, which is what they need to make an arrest. Reasonable suspicion means an officer has a specific, objective reason to suspect criminal activity. This reason must be based on the full circumstances, not just a gut feeling. But here's the tension Jackson identified. How do you evaluate the full picture without examining each fact individually? Any judge writing a decision has to discuss facts one at a time and decide which matter. The difference between doing that fairly and improperly ignoring certain facts isn't always clear. There's also a bigger question about the Supreme Court's role. The justices are supposed to reverse lower courts without full hearings only when the error is obvious. Whether a disagreement about what a teenager's behavior meant at 2 a.m. truly qualifies is debatable. Jackson's dissent is essentially a call for restraint. Not every close judgment call needs the Supreme Court to weigh in. This case shows how courts balance the competing concerns of protecting people from unreasonable police stops while giving officers enough flexibility to investigate genuine threats. The Supreme Court sided with police power here, but Justice Jackson's dissent reminds us that reasonable people can disagree about what suspicious behavior actually means, and that the Supreme Court doesn't need to settle every disagreement among lower courts. Find us online at 9robes.ai. That's the number, 9robes.ai. Like and share this podcast with friends that like to be informed. 9 Robes provides AI summaries of U.S. Supreme Court cases. AI makes mistakes. People make mistakes too. We genuinely do our best to provide you with the most accurate summaries, but our best sometimes includes errors.